Okay, we're going to get started with our first panel discussion. I'm just going to introduce the moderator, and we'll turn it over to him. Our moderator is Thomas Stickrith, who is appointed the Director of the Ohio Department of Public Safety by Governor Ted Strickland on May 26th of this year. He advises the governor and staff on issues related to divisions within the Department of Public Safety, and I'll let him introduce the panel members.
Okay, thank you, Representative. Good afternoon. My badge still says the Department of Youth Services on it, so I think, Terry, that's probably good. Chris Long, is that good backup in case things don't work at public safety? Is there? Yeah, I hear you. Yeah, I can verify that. All right. Well, we've got a great panel today to start the afternoon panels off here, and what experience and what incredible wisdom these folks bring to this panel, and I'm really pleased that they've agreed to be a part of this afternoon. And we did not rehearse, right, panelists? So I've got some really hard questions as I listened to Tony Fabello and Ed Latessa and some of the others this morning. Wrote down some really hard questions, but we do have Judge Mark Schweikert, who's of course retired judge and now executive director of the Ohio Judicial Conference. With us next to him, Victor Vellucci, Portage County prosecuting attorney and past president of the Ohio Prosecuting Attorneys Association. Tim Young, who is, of course, our Ohio Public Defender, and Gail Dittmer, the Franklin County Chief Probation Officer, and Gail, you're past president of OJAC, the Ohio Justice Alliance. So thank you all for joining us. I've got some questions that I did jot down that I'll ask these panelists. You can continue to fill your cards out if you want. Either bring them up here. If I can read your writing, I'll ask it, or you can take that out to the front desk. And then I think if we have time, Terry, after either mine or both of our panels, we can take questions from the floor as well with the mic. So let me just start off with this revolving door theory that I heard. I think it was Dr. Fabello perhaps talked about, Tony, this morning. One of your slides, I think, talked about over 10,000 admissions, maybe it was Marshall's, over 10,000 admissions, fourth and fifth degree felony or property drug offenders. And this group of offenders, as I think the slide showed earlier, or the discussion, was 9 months average in prison before being released, and I think 72% of those received no post-release supervision. And I've seen estimates, Dr. Fabello, that this group cost Ohio about $189 million, $190 million annually in prison operation expenses. And oftentimes, Ohio judges feel that they're left with a prison sentence as the only option for responding to some of these low-level property and drug offenders. And this after repeatedly placing them on sanctions in the community, including probation, diversion programs, and the things that we heard about this morning. Panel members, I'd like your thoughts on what steps we can take with this group of offenders to provide better supervision, sanctions, or treatment to prevent them from, quote, graduating to the adult prison system. So, easy question, and it looks like Judge Schweikert's reaching for the mic and wants to go first. So I'll just, since you sat in that hot seat, Judge, right next to me, do you want to take a first stab at that?
Well, I thought because, is this on?
I think you're on.
I thought because you sat me here, you wanted me to respond first. I wish I had the solutions. I know that all judges in Ohio are concerned about the outcomes of their sentences. I know that they're interested in reducing recidivism. They're interested in protecting the community. They are open to any solutions. And I know that most judges seek out information from the mental health community, from the drug treatment community about how to treat the offenders in their community. They all responded indicating they want pre-sentence investigations that give them information that they can rely on about the offenders and about the nature of the offenders' substance abuse and the nature of their mental health condition so that they can make good decisions about programming. I think a majority of judges are looking for recommendations for treatment plans that they can enforce. So I think what what judges really want is information, treatment plans, resources in their community that they can use to provide those services to offenders, and information about what works. So to the extent that we can do that, I think that's going to help. The concern, I think, is that judges feel that they need to have the ability to send an offender to prison in order to use that as an incentive for the offender to participate in programming. And if you take away the option for revocation, sending offenders to prison, you take away the discipline from the process. And so the judge is faced with a situation where either after giving the offender multiple opportunities to accept treatment and to be successful, we reach the end that you mentioned where don't know what to do. The option is to send them to prison or to say, sir or madam, I've given you every opportunity. We've expended every appropriate resource in our community to help you, and we've been unsuccessful, so go forward. I hope you don't come back again. Thank you very much. That option, if it's the only option, judges are concerned that what happens then is the incentive for others to participate falls away because they know there's no hammer at the end. It's happening in some counties now where there's just not enough jail beds in municipal courts, and municipal courts are finding that in some situations offenders don't even show up for arraignment because they know there's no jail beds. So we need to make sure that that ultimate sanction is available. We just only want to use it when it's absolutely necessary. That means we need to have good treatment plans available for judges to assess, to give these people the right kind of treatment.
Okay, thanks.
I don't have any specific answers. I'm sorry.
We thought you had the exact right panacea.
Yeah, right.
Gail, you want to? Your staff are right on the front line every day with a lot of this population. You want to jump in on that?
I think that we've got a great deal of information now from a lot of research that's been done in Ohio on community corrections, from the original CBCF halfway house study done by the University of Cincinnati, CCA study, which is a lot of the probation programs in the state, and then the follow-up study from University of Cincinnati on CBCFs and halfway houses, which also talks about program integrity. I think we need to take a look at those as a system and try to identify what changes we do need to make within those programs. Ohio has always been a state that's been very willing to take a look at itself, from the governor's office to the legislators to the judiciary to DRC, from Director Wilkinson to Director Collins to Director Moore. I think that a lot of that, when you evaluate yourself, what you get is what you need to try to take a look at to do differently. And through this whole process, I just don't want to lose sight of the fact that Ohio is really a leader in community corrections, and we need to take a look at the studies that we have done to continue to improve what we do. But if we can take a look at ourselves as a system, the regional areas that have a CBCF, halfway houses, probation services, if those systems can, and it is happening in a lot of places where they're working together to try to identify where changes need to be made. But we have offenders that are going through each of those different areas of the system, and we need to take a look at where we need to do things differently. And I think that we can do that. Ohio is known for collaboration, and I think that we can do that based on the information that we have. We just need to keep moving forward, making sure that we're identifying the right people for the right programs and having those quality programs in place so that we can stop that revolving door. Continue to make changes that we need to make in programs so that we're providing the best quality service that we can.
Thanks, Gail. Mr. Prosecutor, you're right up the mic there.
Thank you. Let's focus on this. You know, back in 1996, the legislature gave us a set of laws, including felony fives, which told us and gave the judges the authority to send people to prison for as few as 6 and as many as 12 months on a 5th-degree felony. So I'm not sure why sending them there where they were permitted to go and the law was established is called a revolving door. They're being punished and they're doing 9 months in prison, and maybe that's what it's about. The overriding principle between criminal sentencing in Ohio, according to the statute, is to protect the public and to punish the offender. So perhaps that's the punishment, is 9 months in prison. And while there is some recidivism, a lot of people don't come back to prison after getting a look at it. And there's something to be said for that fact. Having said that, the judge is exactly right. Our system of justice here, our probation system, is a carrot and stick system. So we have the carrots out there, but without the stick, you know, the carrots don't work. And in my experience, anyway, in my county, and we're a middle-sized county with a relatively new jail. In my county, people with first offense felony fives don't go straight to prison. It's pretty tough for me to get somebody into prison with 1 felony 5 on their record. They have had to screw up pretty badly several times before the judge sends them to prison. And that's the stick part. And you have to send a percentage of those people, those offenders, to prison so that the rest of them get the message. I think that's exactly right. And once they're there, the fact that there's no supervision, I think, is a problem. And that's one that we've faced for several years now, and that the Adult Parole Authority does not supervise most felony 3s and no felony 4s and 5s when they come out. So, I think that is a problem that should be addressed. I'm sure that's a budgetary problem, but it's not a problem on the front end. I think the judges are very reluctant to send F5s to prison, and when they do, I think they probably belong there.
Thank you. Well, I guess our public defender gets closing arguments on this issue, Tim.
Thank you. Let me start with the disclaimer, since I'm the public defender in the room. I know where I stand in terms of most people's thought of my opinion about the criminal justice system. And let's start with, I don't know what you do with violent criminals other than segregate them from society. So when you hear me speak, I'm talking about your nonviolent, traditionally low-risk offenders. And I think that's what most of the focus of the work group has been, and most of the focus of trying to reduce this prison population is. And that's who I'm speaking about. So please don't take my comments to apply to anyone and everyone who enters our criminal justice system. And as you might imagine, I tend to focus on protect the public piece of our sentencing statute. And the punish the offender piece needs to be weighed against that protect the public piece. Because ultimately, while you do need that stick, you need to have first verified that you provided appropriate services before you bring the stick down. And so I think there's a lot of room for improvement in Ohio to pass some sort of statewide validity standards for our CBCFs, for our probation departments. Some do exceptional work. Gail works in one of them. Some don't. You reach down to some of your municipal courts. There are no standards at all. There's no training at all for the probation officers. It is simply I kind of call them like I see them report provided to the judge, and you end up with somebody who can then move into your jail, and ultimately, and I think a term that's very important in this question is graduate them to our prison system. And that's the piece that I get concerned about when we talk about being tough on crime versus smart on crime. We get into politically laden terms, and I much prefer to talk about public safety. Because if you measure the public safety piece, then maybe it doesn't make sense. At the end of all of that, if somebody has failed through drug treatment, they failed, and most people will fail drug treatment. Most people with a drug addiction will fail 3 times before they get clean. So you expect failure as part of the recovery process. But if somebody keeps failing out of your probation and keeps failing, but they're a low-risk offender, and they've committed a low-level crime like an F5, and we graduate them to prison, a lot of our evidence that we've collected as part of this says we're creating a higher risk to our public by putting them in prison. We have graduated them. We are educating them. And that's not something DRC is doing. It's because of the peer group that we are now having them associate with. And we're having them associate with more violent criminals. We've taken away their livelihood. And as a result, when they get out, we've increased the likelihood that they'll be back in the community committing a higher level crime or more crimes. And so at the end of the day, if somebody does continue to fail out, you always do need that stick. And I'm not suggesting that a judge should never have that as an option. But I am suggesting that there are times in some of those low-level cases that you simply terminate the case. After 2, 3, 4 years of trying to work them through programming, through multiple different programs, that you terminate it. You don't send them to prison because you don't want to increase the risk to the public at the end of the day. They failed. It will always show up on their record that they failed. The next judge, if they do come back into your system, will see that they failed and will be much more likely to move to the prison alternative because that's the person who did recidivate. But what about the person who never reenters our system? What about the person that by not sending them to prison, we didn't graduate them into our prison system, and we do never see them again, and we haven't increased that percentage of recidivism? So I guess it's a 2-step process. First and foremost, we've got to validate all of the programming. We've got to validate that our probation departments and our community corrections are good programs. Because if you fail somebody out of a program that failed them, they never had a fair chance to begin with to be successful, and we've put them back in front of a judge who doesn't have an option at that point. But we never gave them the chance to be successful because we didn't provide a good program. And Dr. Latessa's work has really come around to giving us the knowledge of how do you validate a program. We know the good ones. We know how to measure the good ones. What we need is a state law that says you can't operate bad ones. If you're operating a bad one, you stop. We stop putting tax dollars into it. We stop putting people into those programs for treatment, and we take over through some sort of a parole system, the DRC taking over the system, whomever, and running a good system and giving all the options for the offender to be successful first. And then, before you choose to pull that trigger for prison, you measure, does it serve the ultimate interest of public safety?
All right, thanks, Tim. Why don't you stay close to that mic, because I'm going to come back to you here in a second. Maybe build in a little bit on what you said and kind of the tough on crime thoughts, and then maybe build on a question I think I heard asked this morning that wasn't answered. And let me try to maybe reframe that question and ask you panelists about this. So panelists, imagine, if you will, a property offender with addictions and no prior felony convictions. What sentence do you think would seem tougher? A 9-month prison term followed by no supervision, or a 36-month probation term with required drug treatment and testing? So Tim, since you're on a roll, we'll stay with you if that's okay.
I'll start with redefining the question just slightly. And I come.
I'm not sure that's allowed, but
it's what defense attorneys do, right? And I'm going to go back to my first response, which is I'd prefer not to talk about the tougher, but what ultimately is public safety and what's our interest here in public safety. And for me, the easy answer to this one, and this is probably the easiest question, is the 36-month probation is better. It's better for public safety. We know that drug addiction is a continuum of treatment. 9 months in prison with very little treatment, addict in, addict out. That's what you're going to get at the end of that 9 months. If you treat them for 36 months, it's probably a lot harder for them, but it's a lot better for us as a society.
All right. Gail, you're ready to jump in.
And I guess my response to that would probably be that it depends on the offender. If it's a lower risk offender who just needs treatment to get back on the right track, he's probably going to do that treatment, he's going to absorb it, and you're never going to see him again. And hopefully he's on the low-level reporting probation or non-probation if he's a low-level offender, or if he's a low-risk offender. If he's a higher-risk offender, he probably needs more than just substance abuse treatment, and it's going to be harder. If he's a higher risk offender, he probably has attitudes, values, and beliefs that have led him to criminal behavior. He may have very low employment skills or no employment skills, so not only does he have to learn how to find a job, but learn those soft skills to keep a job. So I think it's going to depend on the person. If it's a lower risk offender that he just needs treatment and you just kind of let him do the treatment and leave him alone, it's going to be a lot easier. If he's a high risk offender that needs a lot in order to change his behavior, it's going to be a lot harder.
Okay, Victor, do you want to add?
Sure, I'll take it. Try. The question itself obviously is kind of loaded. Is 9 months in prison or 36 months of tough probation, tough.
You can change the question like Tim did.
I'm not. No, I'll go with it. I understand the question, but it kind of depends on the probation department. Some probation departments are, kind of a joke. 36 months there is nothing, and you can fool the probation officer and, skip out, and they won't do anything to you. So that's a pretty easy sentence. 9 months in prison is no walk in the park. That's pretty tough. If you haven't been there before, take a tour. So what's tougher? A good probation department that has trained officers, that truly has drug treatment available to it, can be a tough 36 months if you're a drug addict. Unfortunately, in my county, we don't have any drug treatment. So we're left with, as we said before, sending people to the CBCF because we know that that's the only place they'll get anything close to any treatment. Or taking the urine test every week and then getting flopped to prison anyway. And the premise of the question needs to be addressed also. The person who's doing 9 months, a property offender with addictions and no prior felony convictions, for that person in my county to get 9 months in prison, as I said, he may not have any prior felony convictions, but I'll bet he has 10 or 12 first-degree misdemeanor convictions, and he is screwed up on probation that was already granted to him in the first place, him or her in the first place. So there is not, in my experience, a person sitting in prison for 9 months on a felony 5 who has a pristine record going in.
Judge?
I think they're all right. I recall many offender standing before me and saying, Judge, just give me my time. I've been through this treatment. I can't do it. It's too tough. It's uncomfortable. I don't like it. Just give me my time. I'll do my time. So I think for certain offenders, that 36 months on probation would be miserable, and they know that they probably wouldn't get through the first 3 months, and they'd be back in court anyway, and they don't want to fail again at that. So there are certain offenders that just that treatment option is not something they want. On the other hand, there are many of those that I said, well, I understand you don't want to do it, but I'm going to send you for an evaluation anyway. Talk to the people, find out what's available, and let's see what we can do. And on occasion, they would come back and say, well, I talked with them, and this is the plan, and I think maybe I can make this happen. So there's no question that it's not going to be difficult if it's not enforced. And if it's enforced, there's going to be failures. And those failures are going to need to go somewhere in order for everybody to know that there's a benefit to participating in the program. So I think there's always going to be some people that are going to have to go into some final ultimate sanction, whatever it is. and we need to keep an eye on that. I'd like to go back to one, without changing the question. We talk about, what are things that work. Besides prison being an incentive, I think there are other positive incentives, and I think treatment in lieu of conviction is one that we can consider expanding. Having a felony conviction is a very significant life event, and it affects what your future is going to be dramatically. And I think in a lot of circumstances, the opportunity for treatment in lieu of conviction is a real carrot that's very valuable. And I don't know that I have the exact answer on how it should be expanded, but I think we really should consider expanding treatment in lieu of conviction and giving judges more discretion in granting that option.
Did anybody else want to jump in on that?
Let me talk about that for a minute. And it should be a judge's call. And I've seen judges send people to prison and then grant them judicial release a couple of months before they're due out, and then put them on some reporting requirement. So, you can do both, and the judge should have the option to do that. We should never take away the judge's discretion to do that in these 4s and 5s. Treatment in lieu is an option, but before we expand it, we need to tighten it. There are problems that, unfortunately, there are doctors, there are clinics out there, and I've seen this, where you can go out and get a letter from somebody that says they're visiting you once a week and you're administering this treatment to them. There's no supervision of those doctors or those clinics. They're not truly getting treatment. So if we're going to go in that direction, the state needs to monitor and license very carefully these treatment centers.
This may sound very strange, but I agree with both the judge and the prosecutor.
I think we should just stop right now.
We need to greatly expand treatment in lieu, but we need a centralized validation system for any programs that the justice system's involved in.
Okay, well, I've got a question from the audience here that was handed to me, and let me read that and then maybe put a little different spin on that as well. The question is, it says, panelists, the emphasis of the Justice Center report speaks to the felony 4s and 5s in prison, but should also recognize the risk levels and utilization of the local continuum of sanctions of this population. Is this population part of a revolving door, too, at the local level? Now, before you answer that, let me just add a little spin to that, because we heard this morning, and many of us are aware, and Gail talked about it as well just a few minutes ago, Ohio really has built up this extraordinary network of community corrections. I think Linda Janes, the assistant directors of DRC, are probably responsible for that over the years. That was a joke, Gail. But with that background, this network, is there some agreement of you panel members that we can move toward today in terms of which offenders, perhaps by categories like risk and offense, as mentioned by the person that sent this note up, perhaps by those categories, better suited for sanction options available to judges, straight probation, diversion, halfway house, CBCFs, or prisons? So is there, Gail, you want to start on that one?
If I understood the question correctly, I think that the whole premise of evidence-based practices is risk-based supervision and determining what the needs are specific to that person, and developing a case plan based on the risk related to that person. And I think that we've learned through research that if we do anything but, then we're probably doing more harm than good. And there have been great strides to go in that direction with the ORAS as a statewide assessment tool. As long as we can get that into place and the quality training to go along with it that's been planned, and quality assurance to make sure that that happens, I think that's the direction that we're heading in, and it's going to take some work to get there, but that's where we're going. Did I answer the question?
Yeah, I think so, Gail. Yeah, that was where I was going. I think with the use of, I think, as the letter writer said, tools or assessments. We heard earlier, I think today, from Dr. Fabello that we haven't employed that in Ohio. We've got all these sanctions and these options that are available to courts, but how smart have we been on using those? So maybe could some of the others of you jump in on that? Tim?
Sure. I think one of the greatest failures we can do as a society, or those at least participating in the justice system, are to classify people solely on offenses. It's a mistake to lump everybody together, because you end up with very dangerous people classified identically to people who are of almost no risk. It's very easy to imagine a major drug offender who is an incredible danger to the community being arrested only with a small amount of cocaine on him, and as a result he ends up as a felony 5 offender. If you decide his future based solely upon that offense, and you decide whether you're going to follow up with him on post-release control or how intensive his probation is going to be simply on an offense-based scale, you've made a grave error regarding public safety. We've done that in other areas. We've seen that it doesn't work very well. You need to do risk assessment, individualized risk assessment, to make good decisions about what to do with people and whether they should or should not gain certain services or be on post-release control. If it is solely solely offense-based, we will always be over and under-inclusive in terms of who we need to be supervising and what services they need to be receiving.
Okay. Victor, Mark, you want to?
The part of the question that I want to respond to, and they talked about, is there a revolving door at the local level? That's an excellent question, because our county jail, of course, is full, and we can put name plaques on some of the cells because they're back so often, right? And that's because of, sometimes they're just career criminals, all right? No matter what we do, they're just career criminals. They're going to keep offending and keep offending. Or they have a substance abuse or a mental health issue. And again, unfortunately, in my county, we have very little in the way of local resources to send them to. The state closed the mental health hospitals years ago where we used to send them, and we can't do that anymore. So we have people in jail now that have mental health issues that we can't do anything about. And substance abuse, again, we have very limited resources in our county to address those, so they do end up back in the county jail for weeks and months at a time. I don't know the answer to that.
Mark, you have the answer to that?
I don't have the answer. I think if what we're looking at is the risk assessment tool, I think judges have embraced this idea of risk assessment tool. They've been involved in the development of the latest proposal by the Department of Corrections. I think a lot of courts are already using risk assessment tools that they've developed internally, or that they're paying proprietary rates for, or whatever. I think if we adopt a standard, I think that's a good idea. That the judges are comfortable with the idea that we'll have uniformity around the state. So I think that whole thing is ready to be embraced. Of course, it's not the only thing, and I think you're always going to have some reliance on criminal record, and it's probably always going to be a primary thing item to look at if it's recent history. If it's something that a person did 10 years ago or 15 years ago, maybe not as important, but a current criminal history is probably always going to be one of the most valuable indicators that judges are going to use, and I think it's a big indicator in the risk assessment tool. So it'll be one of the first places. The other thing is, like I indicated before, somebody that refuses treatment and just isn't going to cooperate is probably not going to be successful in a treatment program. So that's another issue that's always, I think, going to be out there.
Putting my juvenile justice hat back on for a minute, I know we had a great success, or we're having some early success, perhaps is better stated, with risk assessment with our Ohio Youth Assessment System. We did a survey of the juvenile courts it's been about 3.5 years ago now, and found out that we were using, in our 88 counties, we were using 66 different types of assessment tools in our courts. Not all bad tools, but some certainly weren't validated or were clearly outdated. And from that, we began working with Dr. Latessa and developed this uniform standardized assessment system on the juvenile side that the juvenile judges have very much embraced, and is paying, I think, some real dividends in terms of some of the sentencing decisions. So I think there's a lot that might parallel there with the adult system as well. Let me go back to a question from the audience, and it says that our panelists have discussed a carrot and stick approach and focused on the sticks. What types of incentives are currently being used? All right, Tim?
I think Judge Schweikert hit it on the head. Treatment in lieu is a carrot. You will avoid getting a felony. There's a great benefit to not having a felony record. Records checks have become so simple, and they continue forever in the age of the internet. Every employer now doesn't want anybody with any felony working for them, and so you end up unemployable. You end up with difficulties in terms of maintaining a license in many instances. You end up then with transportation problems, and you get into this cycle of traffic offenses and then back to crime choices because you can't make a legal living, or you have great barriers to making a legal living. And with that, I think some of the carrots that we can offer through the justice system are things like avoiding a criminal conviction. Diversion programs that many prosecutors' offices run are wonderful carrots in terms of diversion programs are usually limited to people who don't have a drug addiction problem, but first-time offenders on property offenses regularly benefit from those types of programs. So those are a couple of the carrots we use. The avoidance of the conviction altogether is a great benefit both to the individual offender and I think to society at the back end, where you've got somebody who does return to gainful employment, you don't end up with their children in foster care systems, and you don't end up with Medicare, Medicaid expenses for those families. And you end up gaining taxes from that employed person. So those benefits compound from the benefit of not getting the conviction in the first instance.
Go ahead, Judge.
I think this idea of transitioning prisoners back into the community can be a carrot. The idea of coming out of prison and seeing freedom again, and the opportunity for staying that way, I think can be a real carrot. And I think we ought to look more at how we have a transitional controls program now that's probably not utilized as much as it could be. We have reentry courts where judges are working with offenders to try to get them into the programming they need to be successful once they get out of prison. I think that's a carrot, and I think we should keep our focus on that as well.
Okay.
And the supervision end, we can do recommendations to the court for early term if the probationers are doing well. We approve travel permits, but I mean, you would be surprised just how much a program certificate means to an offender who really hasn't completed much in their life. So there's beyond the bigger incentives, just daily incentives often mean a lot to people that haven't had that.
All right, we'll shift to probation. We talked a lot about probation this morning, and we heard a lot from Dr. Fabello about probation, and we know that most criminal offenders sentenced in Ohio are disposed to probation. In fact, Reggie and I were sitting next to each other as those numbers came on the screen this morning, and even having worked as many years as we did in that system, I think, Reggie, we were a little surprised just to see how many people on any given day in Ohio are under probation. Bureau of Justice Statistics, I think, as Tony said, show that Ohio has the largest rate of adults on probation in the Midwest, and that rate is increasing. These statistics alone, I think, demonstrate how important an effective probation system is to our criminal justice system here in Ohio, and in terms of protecting the public and holding offenders accountable. Tony, I think you referred to it in Ohio as a patchwork. Was that the term that I think you used earlier? A patchwork of municipal, county, and state agencies that have wide variations in policies, training, supervision, standards, outcomes, without necessarily being data collected statewide. Tony's presentation, Dr. Fabello's presentation, focused to some degree on the benefits in terms of better offender outcomes on probation when we apply evidence-based practices to departments. And clearly some departments, as we've heard, do better than others in operating along more of these evidence-based practice modes. Are there some opportunities, panelists, whose benefits would be felt across the system, which you could see putting into place standards and guiding principles across our departments from what you heard from Dr. Fabello this morning and some of the comparisons and what we saw Travis versus Bexar County, San Antonio? How does that, or how might that play out in Ohio? Gail, I'll save you for the end since you're a probation expert. I know you're ready to jump right on that question, but we'll save you for the end. But are there lessons learned, and from what we heard from the data this morning, in the system that we have in Ohio with probation, that we can have some lessons learned? Go ahead, Victor. We'll let you start. If you would.
I've got to say, it was an eye-opener for me too. I learned a lot from that presentation. Ohio's very county-based and very territorial, I think, when it comes to their probation departments, and some judges are very proud of their probation departments, and they run them their own way, and that's always been the way that it is. And it truly was very informative for me to hear those statistics, and I can certainly see the benefits of some standardization and some consistency across the state for what's expected of probationers. I think it might be a tough sell for some of the judges, though.
Mark?
We have to remember that the role of the judge in sentencing is to formulate an appropriate and fair sentence in each unique situation. I think standards, uniform standards across the state in certain areas probably make sense. It depends on how detailed that is and how strict they are. Judges are always going to feel that their purpose there is to make sure that the specific sentence fits the crime and fits the offender. That's what they're there for. That's why they're the arbitrator in the middle of that adversarial process that goes on between the defense attorney and the prosecutor. So I think some standards make sense. But we need to retain a discretion for the individual judge on applying those standards in a specific situation. I'm very nervous about saying, well, the data says that this offender is in this class and you can only do this with them because that's where they are. That really bothers me.